consequences of the objection if it were to be upheld, and only in the very specific context of the Geneva Agreement.
Furthermore, when the 2018 order was adopted, it was already perfectly clear that it was the validity of the award that was at the heart of the dispute. The application instituting proceedings is explicit on this point, as is the Geneva Agreement. It was also already perfectly clear that Venezuela challenged the validity of the award on the basis of the UK's conduct. In 1962, when Venezuela first argued that the award was null and void, it was purportedly because it was supposedly the result of a political transaction carried out behind Venezuela's back, unquote. Considering that it was reproduced word for word in the application, this claim was something that the court was familiar with when the 2018 order was adopted. This claim is vague and unclear, but it directly implicates the United Kingdom because, after all, who else could it possibly be? If it was the arbitrators, then the monetary goal principle does not apply. Professor Sounds will come back to that. If it's not the arbitrators, it can only be the United Kingdom itself. And this is what Venezuela was unable to establish on the basis of your judgment.
It is therefore simply fallacious to repeat that your 2020 judgment would have revealed that the UK's conduct is at issue in this case. The truth, and however it does concern the merits, the truth is probably that Venezuela itself does not very well why nor because of whom the award is to be found null. However, it is clear that Venezuela already knew in 1962 that it had complaints about the UK and the way in which the arbitration had been conducted, and that it deduced that there was reasons for nullity. It should have explained this in accordance with the order. Indeed, by asking the parties to set out their arguments on the question of your jurisdiction, you necessarily ask the parties to develop the reasons for which, whereas your jurisdiction is established under Article 4 of the Geneva Agreement, you would be precluded from exercising it. And I would like to note in this respect that Professor Zimmerman did not dispute the fact that the monetary goal principle precludes the court from exercising its jurisdiction. Madam President, members of the court, from now on, and for the first time during this incident proceeding, Venezuela is claiming that its preliminary objection also concerns the related question of the definitive settlement of the territorial dispute between the parties. According to Professor Zimmerman, this second question, because it is linked to the first question relating to the validity of the award, the alleged inadmissibility of the first question by virtue of the monetary goal principle should lead to the inadmissibility of the second question. Members of the court, this last-minute deft move by Venezuela reveals, in fact, that Venezuela should have explained in accordance with the 2018 order why the related question was not within your jurisdiction, nor should it call for you to exercise it, because if this question is outside the purview of your jurisdiction or it's exercised because it is linked to the validity of the award and would be infected by the application of the monetary goal principle, Venezuela should have also explained why the absence of the United Kingdom was a critical impediment to your exercising your jurisdiction regarding this related question. Madam President, the second reason that impedes an examination of the grounds on which the preliminary objection is based and precludes its being upheld is the December 18, 2020 judgment. I will not repeat what my colleague, Mrs. Beharry, set out so clearly on Friday. Professor Zimmerman said nothing of paragraph 121 of your December 2020 judgment. He said nothing to the effect that your judgment had decided the court has
jurisdiction to entertain the application, terms which indicate with res judicata effect that the court has jurisdiction to examine the merits of the case and that it has decided to exercise that power. Finally, Professor Zimmerman did not explain at all how it would be possible to undo your 2020 judgment in its wording with a judgment that would uphold the preliminary objection, regardless of what such a decision might be called. Invoking the Noteboom case, he said that he was stunned by the argument presented by Mrs. Biari. It is rather the fact that the Noteboom case is being invoked by Venezuela to get around the res judicata effect of the 2020 judgment that is stunning. Professor Zimmerman asserted before the court that the court confirmed in 1953 that it had jurisdiction to entertain the case. However, the 1953 judgment had done no more than reject a preliminary objection on admissibility, which is a far cry from stating positively, as you did in 2020, that the court had jurisdiction to entertain such claims. Furthermore, while the 1955 judgment put an end to the proceedings by declaring inadmissible Liechtenstein's application, this was on account of Mr. Noteboom's nationality. This has nothing to do with the conundrum, with the impasse into which Venezuela is urging you to plunge. I would like to add, finally, that it is somewhat of an insult to the collective intelligence of the court to claim that by ruling in December 2020, you could not have realized that by examining the validity of the award, as you had decided to do, you could be led to necessarily
look into the conduct of the United Kingdom at the time of the arbitration. This is all the more so that the court ruled in the absence of Venezuela as prescribed by Article 53 of the statute. Madam President, I would like to thank the court for its kind attention and would like to ask you to invite Professor Sands to the bar.
I thank Professor Dargent, and I now invite the next speaker, Professor Philippe Sands, to take the floor. You have the floor, Professor.
Madam President, members of the court, it falls to me to deal briefly with 4 substantive grounds for rejecting the preliminary objections in the absence of my dear friend Mr. Reichler for reasons that are known to you. First, only the conduct of the arbitrators, not that of the United Kingdom, could provide a basis for invalidating the 1899 Arbitral Award. Second, the monetary gold principle is not engaged in this case. Third, the parties agree that the United Kingdom has no legal interest in the boundary. And fourth, the United Kingdom has consented to the court's jurisdiction in this case and to the exercise of that jurisdiction. I turn first to the allegation of wrongful conduct, which has been put variously as fraud, corruption, or deceit, but without any specificity. The gravamen of the Malay Prevost allegations was wrongful conduct on the part of certain members of the Arbitral Tribunal. And in the first round, Professor Tams still recognized the need to establish the wrongful conduct of the Arbitral Tribunal, although he did shift the argument in part to the wrongful conduct of the British government or its legal team. If a tribunal is corrupt, he said, someone must have corrupted it. You cannot collude on your own. But in the second round, as I'm sure you will have noticed, the argument had completely changed. The court heard not a single word, not one word, about the wrongful conduct of the arbitrators. And now the case was entirely about the wrongful conduct of the United Kingdom. Professor Tams was succinct, and I quote, "The arbitral award is invalid because of the fraud committed by the United Kingdom in the arbitration, he told you yesterday. But the alleged wrongful conduct of the arbitrators has just vanished, despite the fact that the court has ruled that its jurisdiction is focused on the validity of the arbitral award. To succeed on the merits, it is not enough for Venezuela to prove wrongful conduct attributable to the United Kingdom. It will not be sufficient to argue that a British lawyer perhaps expressed a desire to communicate with an arbitrator or actually sought such communication. Venezuela's burden is to prove that one or more of the arbitrators engaged in inappropriate contact with counsel, and this is what influenced the award. It has offered no evidence to support such an argument. Nothing. And this is Venezuela's central problem on this point. The central question of a potential merits decision is clear, Professor Tans told you. Is the award invalid because of the conduct of the United Kingdom? End of quote. With respect, that is the wrong question. The right question is this one. Is the award invalid because of the conduct of any of the arbitrators? And on that question, Venezuela was completely silent. Its evidentiary cupboard is bare, empty. Venezuela offers no authority whatsoever for the proposition that the conduct of a party in arbitral proceedings can of itself taint an arbitral award. And we're not aware of any case of an arbitral award being set aside merely because of the conduct of a party or of its counsel. What is relevant is the conduct of the arbitrators. Now, we are all painfully aware of the unhappy recent arbitration between Croatia and Slovenia. Yes, there was incontrovertible evidence of wrongdoing by the agent of Slovenia and by the arbitrator appointed by Slovenia. Would the problem have been as grave if there had only been misconduct by the agent? Of course not. To be sure, misconduct by an agent or counsel is totally inappropriate, and it may incur professional or other consequences. But in the absence of evidence of misconduct by an arbitrator, it will not of itself taint the outcome. What truly mattered in that case was the misconduct of the arbitrator, which was clearly proven. By contrast, in the present case, Venezuela has offered no evidence of any misconduct or wrongdoing by any arbitrator. Its counsel said absolutely nothing about that in the second round. And that's because their counsel understand that you cannot make so grave an allegation without evidence, and there is no evidence. And that, presumably, is why Venezuela said nothing about the material to which we drew your attention, the clear evidence that Professor Martins and his fellow arbitrators acted with impeccable integrity, independence, and impartiality. Venezuela's silence means that our evidence is completely unchallenged. But even if there was such evidence, what would be the consequences for a party to the proceedings? You would have to rule on the state responsibility of the United Kingdom, says Venezuela like a broken record. Really? No. A finding of misconduct by arbitrators might, of course, be connected to evidence, factual evidence of wrongdoing attributable to the United Kingdom, but that would not require the court, in a judgment, to address the state responsibility of the United Kingdom. Because the court's role in this case is limited to the validity of the arbitral award, which is the very subject matter of this dispute. And that turns on the conduct of the arbitrators. If you find no such misconduct, the consequence is clear. The award is valid. A finding of misconduct by arbitrators may require factual findings in relation to acts attributable to the United Kingdom, but not any legal findings in relation to the responsibility of the United Kingdom. That's outside your jurisdiction. It's a red herring. The only conduct you have to address is that of the arbitrators. All the rest is noise. The second reason Venezuela's preliminary objections fails is that even if, quod non, the lawfulness of Britain's conduct up to and in 1899 was relevant, Venezuela has not established that it forms the very subject matter of the dispute to be resolved by the court. As I said, the subject matter is the validity of the award, which does not turn on the conduct of any state, not Britain, not Russia, not Venezuela, not the United States. Professor Tams likens this case to monetary gold and East Timor, but there's no similarity between those cases and this one. In monetary gold, if the court had ruled on Italy's claims against Albania, it would have passed judgment on the rights and obligations of the absent state, and that is what the court said. Similarly, in East Timor, the court would have had to pass judgment on Indonesia's rights and obligations in respect of treaty-making power on behalf of East Timor. In this case, the court is called upon to express views and rights and on the rights and obligations not of any state, but in relation to the behaviour of the arbitrators. That is the cardinal difference. We've pressed and pressed Venezuela to explain specifically what legal rights and obligations of the United Kingdom would constitute the very subject matter of a judgment in this case. Professor Tams would not tell you. Instead, he passed the buck to Professor Palchetti, who, in the first round, simply tried to avoid the issue. At this stage, he said, it's immaterial to establish the precise consequences that may flow from the United Kingdom's unlawful conduct. The best he could come up with was that the arbitral award would be invalidated, that Article 69 of the Vienna Convention would return the legal situation to the status quo ante, so that the boundary would be undetermined and the territory once again disputed. What are the consequences of any of that for the legal interest of the United Kingdom? There are none, we say, because self-evidently, today it has no interests in the validity of the arbitral award, the land boundary, or the disputed territory. Now, yesterday, Professor Palchetti struggled somewhat, but he did manage to come up with one more alleged consequence for the legal rights and obligations of the United Kingdom. If the arbitral award was set aside, Venezuela would be able to claim reparations from the United Kingdom for, as he put it, exploiting territory that belonged to Venezuela. With great respect, this truly is an extraordinary argument, a desperate attempt to manufacture some sort of a legal interest of the United Kingdom that might be said vaguely to be connected to the very subject matter of this judgment. In rendering a judgment on the validity of the arbitral award, the court would not remotely have to consider the United Kingdom's post-award conduct or to rule on Venezuela's supposed entitlement to reparations for the United Kingdom's post-arbitral award administration of territory awarded to it by the arbitrators. Now, Professor Tams artfully avoided any discussion of the consequences for the legal rights and obligations of the United Kingdom. He didn't speak of rights and obligations, which says a lot. Instead, he again applied the wrong test for the application of the monetary gold principle, the same one he put forward in the first round and which we exposed as erroneous. In the second round, Professor Tams sought to buttress his position by citing language from the phosphates case, about which he said nothing in the first round, that monetary gold would apply when the court is required to rule on an absent state's conduct as a prerequisite to issuing the judgment it has been called upon to make. But this new argument changes nothing. In the first place, as we've made clear, the court is not required to rule, in a legal sense, on the United Kingdom's conduct at all. It is only required to rule on the conduct of the arbitrators in issuing its judgment on the validity of the 1899 award. Second, and in any event, the test is not whether the court has to rule on the conduct of an absent state, as the court has repeatedly made clear, but, as in East Timor, whether its ruling would affect the legal rights and obligations of the absent state, such that they would constitute the very subject matter of the dispute. Professor Tams hovered above the surface of this issue like a dragonfly, avoiding all contact with the murky waters below. He just avoided the question of whether the court's judgment would affect the legal rights and obligations of an absent state, such that they would constitute the very subject matter of the issues to be decided. If this case is like any other in the court's jurisprudence, it is Cameroon versus Nigeria, where the court exercised jurisdiction over Cameroon's boundary claim in Lake Chad, even though part of the boundary was the tri-point with Chad. The court didn't consider that this made Chad's rights the very subject matter of the dispute. Venezuela's argument is lesser still, as the UK has no interest in any point along the boundary between Guyana and Venezuela. This takes us to the third ground for rejecting Venezuela's preliminary objections. Venezuela has admitted repeatedly that the United Kingdom has no legal interest in the boundary between Guyana and Venezuela. As a consequence, it should admit that the court is entirely free to exercise its jurisdiction with respect to the second issue, over which the court ruled that it has jurisdiction in its judgment of December 2020, the related question of the definitive settlement of the land boundary dispute between the Cooperative Republic of Guyana and the Bolivarian Republic of Venezuela. However, as Professor Dargent just recalled, Venezuela suddenly changed its mind and now argues that its monetary gold objection somehow infects the related question because it's related to the issue of the validity of the award. How convenient, it might be said, but plainly wrong in light of the monetary gold test applied to this related but nevertheless entirely separate claim. Professor Tams displayed on the screen the wrong issues to be decided by the court, and which he then claimed formed the very subject matter of the dispute. He took those issues from Guyana's memorial. But the memorial cannot determine these issues, following the court's judgment on jurisdiction, in which the court identified the issues to be decided as the validity of the 1899 award and the related question of the definitive settlement of the land boundary dispute between Guyana and Venezuela. Venezuela obviously has nothing to say about the second issue, except its infectious approach. And with its silence, it concedes that the court can exercise jurisdiction over this issue. Nor would there be any impediment to the court fixing the international boundary exactly where the arbitrators did, in light of Venezuela's formal agreement to it in 1905, and its scrupulous conformity to that boundary for more than 60 years, as its own official maps demonstrate. Moreover, in conceding that the court may exercise jurisdiction over the determination of the land boundary, Venezuela effectively concedes in our submission that it may exercise jurisdiction over the entire arbitral award, whose sole purpose and effect was to fix that boundary. Which brings me to a fourth basis for rejecting the preliminary objections. On Friday last, we explained that the 1966 Geneva Agreement embodies a clear expression of consent by the United Kingdom to the Court's exercise of jurisdiction over Guyana's claims, which explains why the issue of its participation as a party to these proceedings simply does not arise. We hoped to hear a meaningful, substantive response to that argument. Professor Palchetti did mention the argument briefly, en passant, but he did not engage with the substance of the issue or any of the evidence to which we referred you, and he glossed over or completely ignored all the critical points. Professor Palchetti's principal response was to assert that Article 4 of the Geneva Agreement provided no support for Guyana's argument, since those provisions make no mention of the United Kingdom. They are, he said, intended only to set out practical arrangements for the parties. That submission is, we say, completely flawed. First, the fact that the United Kingdom is not expressly mentioned in Article 4 is totally irrelevant to the question of whether or not the United Kingdom has consented to the Court exercising jurisdiction over Guyana's claims. The existence of consent by the United Kingdom is manifested and evidenced through the United Kingdom's signing of the Geneva Agreement. By signing and being a party to the 1966 agreement, the United Kingdom consented to all of the provisions of the agreement, including Article 4. It has consented to all processes for the resolution of the controversy conducted in conformity with these provisions, including those conducted pursuant to the process established under Article 4, Paragraph 2, including these proceedings. The fact that the United Kingdom is not mentioned in Article 4 is, however, relevant for a different reason. It demonstrates that the three parties to the Geneva Agreement intended that only two of them, namely Guyana and Venezuela, would play any role in selecting and participating in the means of the settlement of the controversy. In other words, all three parties to the Geneva Agreement explicitly recognized that only two of them, Guyana and Venezuela, had any legal interest in the disputed issue concerning the validity of the 1899 award. The third party, the United Kingdom, explicitly recognized that it had no such interest. This Venezuela recognized in its 2019 memorandum submitted to the Court, a point which Professor Palchetti did not dispute yesterday. Second, Professor Palchetti's characterization of Article 4 is not accurate. The agreement established a binding procedure for the selection of means of settlement of the controversy. This included, ultimately, conferring a power on the Secretary-General of the United Nations to choose one of the means of settlement provided in Article 33 of the Charter of the United Nations. And if that means of settlement did not resolve the controversy, to choose another of the means stipulated in Article 33. As the Court observed in its judgment at the jurisdiction phase, the object and purpose of the Geneva Agreement is to ensure a definitive resolution of the controversy. Third, it is telling that Professor Palchetti entirely failed to address the critical point that it would be absurd to construe the Geneva Agreement as having simultaneously empowered Guyana and Venezuela or the Secretary-General to refer the controversy regarding the validity of the 1899 award to the Court, while at the same time rendering the power nugatory by requiring the court to decline to exercise jurisdiction on monetary gold grounds. The absurdity, the total absurdity of that approach is thrown into even starker relief by the fact that the United Kingdom expressly envisaged the possibility of the controversy being referred to the court pursuant to the Geneva Agreement. As the court explained at paragraph 107 of its judgment of 18th of December 2020, and I quote, "The parties to the Geneva Agreement intended to include the possibility of recourse to the International Court of Justice when they agreed to the Secretary-General choosing among the means set out in Article 33 of the Charter of the United Nations." The Court's use in this paragraph of the words "the parties" includes the United Kingdom. How could it possibly be the case that the parties to the Geneva Agreement, including the United Kingdom, intended to enable the controversy to be referred to and determined finally by the court, while at the same time rendering such a determination by the court impossible on the basis of monetary gold? We're still waiting for an answer from Professor Palchetti on that question, or from anyone on the Venezuelan side. I suspect we will wait a very long time, maybe even another 123 years, when perhaps Venezuela will come back to this court armed with a deathbed letter from one of its counsel alleging that he or she spotted in the demeanour of one of these judges before me a change between last Thursday and today. It is an absurd proposition. It makes one feel, as probably others do, as though we are characters from a novel by Gabriel Garcia Marquez. Indeed, Venezuela's monetary gold argument falls foul of the same obstacle identified by the court at paragraph 115 of its December 2020 judgment. This held that a requirement of further consent before the court could hear Guyana's claims pursuant to Article 4 of the Geneva Agreement would frustrate the very object and purpose of that agreement. It is worth recalling with care what this court ruled. The decision taken by the Secretary-General, in accordance with the authority conferred upon him under Article 4, paragraph 2 of the Geneva Agreement, would not be effective if it were subject to the further consent of the parties for its implementation. Moreover, an interpretation of Article 4, paragraph 2 that would subject the implementation of the decision of the Secretary-General to further consent by the parties would be contrary to this provision and to the object and purpose of the Geneva Agreement, which is to ensure a definitive resolution of the controversy, since it would give either party the power to delay indefinitely the resolution of the controversy by withholding such consent. In exactly the same way, Madam President, an interpretation of Article 4.2 to the effect that it envisaged an application of the monetary gold principle in the way argued for by our friends from Venezuela would also be contrary to the provision of Article 4 and to the object and purpose of the 1966 agreement. The Court's judgment of December 2020 deserves to be read with great care. Venezuela has no good answer to the proposition that by signing the Geneva Agreement, the United Kingdom has explicitly expressed its consent to the court exercising jurisdiction over Guyana's claims which have been brought pursuant to that agreement. And finally, this conclusion is fully confirmed by the various statements that have been made by the United Kingdom and to which we drew your attention last week. Statements made in the period after the signing of the 1966 agreement and, very much more recently, in the period after the court gave its judgment in December 2020. And once again, Venezuela offered you, the court, no alternative interpretation of these many statements. Once again, Venezuela passed in complete silence. It failed to deal with points that are so very difficult for its own case. Madam President, members of the court, that concludes my submissions on the 4 points. And to conclude for Guyana, I invite you to call the agent of Guyana to the podium.
I thank Professor Stans for his statement, and I now give the floor to the agent of Guyana, the Honourable Carl B. Greenidge. You have the floor, sir.
Madam President, distinguished members of the court, I begin with an observation and a question. As will no doubt have been apparent to the court throughout this hearing, Venezuela's arguments in support of its preliminary objections have been rather long on allegations and rhetoric, but somewhat short on substance. One thing, however, is abundantly clear. Venezuela really does not want this court to determine the merits of Guyana's claims. Why, one might ask, is that the case? Is it because Venezuela is sincerely concerned that the judgment on those claims will, in its very essence, involve a determination of the rights and obligations of the UK? Or is it because Venezuela recognizes that the legal and factual merits of Guyana's claims are overwhelming, and that a hearing on the merits of those claims will yield only one possible outcome, namely a judgment adverse to Venezuela's territorial aspirations? The answer we submit is obvious. In my opening speech on behalf of Guyana, I noted the irony that Venezuela, a proud, long-standing and vocal opponent of colonialism, was seeking to invoke the rights and dignity of a former European colonial power to prevent this court from determining a claim brought by its former South American colony, Guyana. However, that is not the only ironic aspect of Venezuela's current stance. Yesterday, the agent for Venezuela emphatically proclaimed that Venezuela has established the truth about a historic wrong committed against it by the 1899 award. And he declared that, and I quote, "We come to the International Court of Justice to tell such a historical truth." In the same breath, he also stressed Venezuela's firm commitment to international law. However, despite these impassioned proclamations, Venezuela remains strangely reluctant for the merits of its version of the truth to be exposed to independent scrutiny and determination in accordance with international law by the principal judicial organ of the United Nations. As Guyana has shown, Venezuela's position is contradicted by the historical record, including its enthusiastic and decades-long embrace of that award and the boundary which it established. Venezuela's narrative, which began shortly before Guyana attained independence in 1966, ignores these fundamental contradictions and constantly evolves. Yesterday, it even claimed it had been dispossessed of territory by the Arbitral Award. Against this backdrop, one cannot escape the conclusion that it is a desire to continue perpetuating a falsehood rather than a desire to expose and vindicate the truth that underlies Venezuela's hostility to the court hearing Guyana's claims. Instead of proceeding to determine the merits of Guyana's claims, Venezuela urges the court to decline to exercise jurisdiction so that the dispute between the parties could instead be resolved through a process of negotiation. By making that argument, Venezuela once again invites the court to condemn the parties to perpetual deadlock and the indefinite continuation of a controversy which has blighted their relations for the entirety of Guyana's existence as a sovereign state, which has nothing less than existential significance for Guyana. This is not a situation where there is even the slightest glimmer of possibility that a long-standing dispute between the parties could be resolved through negotiation. There is a simple and fundamental reason for this. As this hearing has demonstrated, Guyana and Venezuela hold entirely intractably opposing positions regarding the validity of the 1899 award. Guyana maintains that the 1899 award and the boundary which it established are valid. Venezuela maintains the opposite. These positions have been entrenched since Guyana's emergence as a sovereign state some 56 years ago. All previous efforts to resolve the controversy through mediation or negotiation have failed. As the court knows, these efforts included a 4-year mixed commission and an intensive 27-year good offices process involving no fewer than 4 successive secretaries general, including a final year of enhanced mediation. After more than half a century of unsuccessful attempts to resolve the dispute through mediation and negotiation, processes in which Guyana engaged wholeheartedly, the Secretary General of the United Nations concluded that, and I quote, significant progress has not been made toward arriving at a full agreement for the solution of the controversy, end of quote. It was for this reason that he chose the court as the means to be used for the solution of the controversy. As the Secretary General expressly recognized, and as Venezuela well knows, the only hope of a resolution of the controversy lies in a binding and final determination of Guyana's claims by this court. It is for this reason that Guyana brought those claims before the court in 2018. And it is for this reason that Guyana once again affirms its complete faith and confidence that the court will proceed to adjudicate those claims independently, impartially, and in accordance with international law. Madam President, I will now close Guyana's oral pleadings by reading the final submissions. For the reasons stated in Guyana's written and oral pleadings, Guyana respectfully requests the court, 1. Pursuant to Article 79, paragraph 4 of the rules, to reject Venezuela's preliminary objections as inadmissible or reject them on the basis of the parties' submissions. 2. To fix a date for the submission of Venezuela's counter-memorial on the merits no later than 9 months from the date of the court's ruling on Venezuela's preliminary objections. Madam President, members of the court, I should like to conclude by expressing, on behalf of Guyana, its delegation and all of its people, our sincerest thanks and appreciation to all the members of the court for your patient attention throughout this hearing. I also express our gratitude to the registrar, his staff, and the court's interpreters for the professional and courteous assistance which they have provided to the parties, assistance which has ensured the smooth running of the proceedings. And finally, I would like to express our deepest respect, esteem, and friendship to the members of Venezuela's delegation, whose presence in the Great Hall of Justice throughout this hearing we warmly acknowledge and appreciate. Thank you all very much indeed.
I thank the agent of Guyana. The court takes note of the final submissions of the Cooperative Republic of Guyana, which you've just read on behalf of your government. This brings us to the end of the hearings on preliminary objections raised by the respondent in the case concerning the Arbitral Award of 3 October 1899, Guyana versus Venezuela. I thank the representatives of the parties for the assistance they have given the court by their presentations in the course of these hearings. In accordance with practice, I shall request the agents of the parties to remain at the court's disposal to provide any additional information the court may require. The court will now retire for deliberation. The agents of the parties will be advised in due course as to the date on which the court will deliver its judgment. Since the court has no other business before it today, the sitting is now closed.